Hey, how's it going? My name is Gabey, and just like it says in the title, today I'm going to be telling you the story of how I sued a record label and won. So before I start, I just got to say that I'm not a lawyer, and what I'm going to tell you is not professional legal advice. I'm just a musician, I'm a producer, I'm an audio engineer. If you're new to the channel, feel free to check out some of the music I've posted and my other content. But yeah, I'm basically just a normal guy that got fed up with getting taken advantage of by record labels, so I decided to fight back. Also, I live in the state of California, so a lot of the laws that I'm going to be talking about are just laws here in this state. So if you're using this video for research or anything like that, I suggest that you do the research on the laws of your state or where you live before you take any action or seek any legal advice. I hope you enjoyed the video, and if you do, or if you learn anything new at any point, make sure you click that like button and share this video with a friend or family member who may be going through a similar legal issue. I'm going to be using some fake names because I don't want to get sued for defamation by this record label, but there are a few key players you need to keep in mind. First, we have my friend, who is another audio engineer who I've known for a few years. We're just going to call him my friend. Next, we have the artist that I recorded that night. He was actually pretty cool and he had nothing negative to do with this case, so we're just going to call him Mr. Rapper. Then we have Mr. Rapper's manager, who we're going to call Bum Ass Manager. Next up, we have the record label, who we're gonna call Dumbass Records. Then we have two employees for Dumbass Records, who we're gonna call A and B. And finally, we have one of the session musicians from the recording studio that night, who we're gonna call My Guy. Just keep in mind, my friend and my guy are two different people. Got it? Great. Let's get into it. So on August 8th, 2023, I got a call from my friend. He told me Mr. Rapper's audio engineer couldn't make it to the session that night and needed a replacement. My friend was also busy that night, so he called me to see if I could take his place. I told him I was free and I'd be happy to do it, so he said, let me speak to Mr. Rapper's manager and I'll get back to you. A few minutes later, my friend texted me Mr. Rapper's manager's phone number. So I texted Mr. Rapper's manager and I just said, hey, this is Gabe, I'm free that night. This is my rate to record. Does that work for you? And he said, yes, sir. Then we just talked about the details of the session, what time it was, where the studio was, and anything else I needed to know before pulling up. Mr. Rapper's manager was very responsive before the session. We had a lot of calls and texts back and forth, and everything seemed to be going great. I showed up about 15 minutes early just to get everything set up, get the Pro Tools ready, get familiar with all the gear because it was a new studio I'd never been before. I got everything set up and Mr. Rapper came through with a whole group of musicians, including my guy. But for some reason, Mr. Rapper's manager wasn't part of the team that showed up to the studio. The session was a lot of fun, it was 4 hours long, and my guy was basically playing guitar and piano and recording a lot of samples that I would export and then send to all of the other producers that came with Mr. Rapper. Then they used those samples to make beats on their laptops with headphones while my guy and I kept grinding out more samples. Mr. Rapper didn't actually record anything that night, he was just there having a great time, and it was really a lot of fun that session. The session ended at around 3:30 in the morning, it was pretty late when we all left, and they just told me to get in touch with Mr. Rapper's manager the next day about getting paid. Even though typically for a session like this where I'm operating Pro Tools, I would typically get cashed out at the end of the session, or like a Venmo, PayPal, Cash App sort of thing like that. But like they said, I just waited till the next day to reach out to Mr. Rapper's manager. So the next day I text Mr. Rapper's manager that the session went well and wondering when I was gonna get paid, and essentially from there on out, he went totally ghost on me. And that's when Mr. Rapper's manager turned into Bum Ass Manager. So that wasn't the first recording session I did, and that wouldn't be the first person that ghosted me after a session about getting paid, so I kind of knew what was going on, and I wasn't going to stand for it. I put together an invoice for the hours in the session, and I sent it to Bum Ass Manager and told him that he had 2 weeks to pay the invoice. Now, like I said, this isn't the first time someone has ghosted me about payments. I've done a lot of freelance gigs in the creative industry, such as background acting, working as a boom operator, holding a microphone for TV and film sets. So I have a lot of experience freelancing for different companies and different people, and unfortunately, I've been the victim of wage theft far too many times. Companies haven't paid me correctly, they haven't paid me on time, or they just have flat out refused to pay me for the work I do. If you work in a creative industry, you know just how widespread this issue is, and part of the reason I'm making this video is to teach and encourage others on how to fight back. I eventually got so fed up with being the victim of wage theft that I looked into my local laws, and here in California, there's a mandate in California Labor Code Section 207 that says work that is completed between the 1st and 15th of the month needs to be paid by the 26th of the month. And work completed between the 16th and the final day of the month needs to be paid by, I think it's the 10th or the 11th of the next month. So that law, California Labor Code Section 207, is a law that I used in this case and the law that I used in previous cases of wage theft to file claims against companies. So that's why I gave bum-ass manager 2 weeks to pay me, and if he didn't, then I would have grounds to start a claim. So that same day, I sent an email to my guy asking him how he usually gets paid from those sessions and who I should contact. He told me that bum-ass manager would take care of it and that we're dealing with major labels, so at some point something would get taken care of. But I told him that bum-ass manager wasn't really answering me, so he said he would get me in touch with the record label, which is why he is my guy. So a few days later, I got an email from A at Dumbass Records, and in her email, she copied bum-ass manager and B from Dumbass Records. In her email, she told me she was sorry for the confusion and didn't realize that I was filling in for another audio engineer and that she would get it taken care of as soon as possible. I also got another email from B at Dumbass Records with invoicing instructions on how to send an invoice to Dumbass Records. In those first emails from A and B at Dumbass Records, they told me that Dumbass Records pays on net 30 to 90 terms, meaning it would take me 30 to 90 days to get paid. Now, to my understanding, that goes against California Labor Code Section 207, which I mentioned earlier. And while I wasn't really okay with it, I complied and I sent them an invoice basically as a formality to hopefully speed up the payment process. So I sent Dumbass Records an invoice with net 30 to 90 terms, but I told A that I would like to have the money by August 26th in accordance with California state law because I did not agree to net 30 or 90 terms before I went to the studio session. They had told me that it would take 30 to 90 days to get that little bit of money for those 4 hours of work, then I simply would have just not gone. And that actually became one of the major points in the foundation of my claim against Dumbass Records, which was that it was unlawful for them to impose net 30 to 90 payment terms after I had already rendered the services without agreeing to those terms verbally or in writing beforehand. So after sitting around for a month and not getting paid, I reached out to A at Dumbass Records and I expressed my frustration of having to wait so long for getting paid and said that I would be filing a claim if I was not paid by October 1st. Again, in my eyes, my money was owed to me by August 26th because I performed the work on August 8th, so that was basically already over a month late. October 1st came around and I did not get paid. October 2nd rolls around, and on October 2nd, I get a wire transfer from Dumbass Records for the money that I'm owed for the session. So finally, after almost 2 months of waiting, I get paid for a measly 4 hours of work. This became the second foundation of my claim, which was that I was paid over a month late. I was paid on October 2nd when I should have been paid on August 26th. Now, what I also know about California law is that California Labor Code Section 203 includes something that's called a waiting time penalty. And the waiting time penalty is money that you are owed if you are paid late by an employer. The waiting time penalty is calculated by taking the employee's full day of pay and multiplying it by the amount of days the employee was paid late, up to 30 days. So the waiting time penalty in my case was my full 4 hours of pay times 30 because it took over 30 days for Dumbass Records to finally pay me. So on October 2nd, I went to my local labor department website and I filed a claim against Dumbass Records seeking the full 30 days of waiting time penalty. A few months later, I got this in the mail. This is a letter from the State Department of California that is the Notice of Claim and Conference. This piece of paper states that a claim has been made, it gives me a case number, it tells me when there is a conference that is going to be had. The purpose of the conference is to discuss the validity and to settle the claim filed. In these conferences, both parties meet via phone call to discuss whether they want to settle the claim before it gets presented to a judge. If a judge rules in favor of the plaintiff, then they're granted the full claim, or the judge can throw out the claim and give them nothing. If there is a valid claim, it's usually in the best interest of the accused party to settle before going to the judge because they can incur legal fees as well as having to pay the full amount in the claim. And in my case, Dumbass Records hired 2 lawyers to represent them in this conference, and they did what they were supposed to do, which was settle the case for as little as possible. But here's where the story gets juicy. A week before my conference, I got an email from the Labor Department office saying that the defense sent a letter in response to my claim. The letter came from the law firm representing Dumbass Records. In it, they wrote that they believed that my case was without merit and asked that it be dismissed. Then, they listed 5 reasons why they think my case should be dismissed. These are those 5 reasons. Number 1, Dumbass Records is an independent record label. Dumbass Manager, a personal manager of one of Dumbass Records' exclusive recording artists, directly independently engaged Gabey Baby to render music engineering services for Mr. Rapper on a one-time basis for a period of approximately 4 hours. Number 2. Dumbass Manager has never been in any manner whatsoever authorized to act or to assume any obligations on behalf of Dumbass Records. Number 3. Dumbass Records was not made aware of the services until after they were already rendered for Mr. Rapper, and Dumbass Records did not have any input or control over how Gabey Baby performed the services. Number 4. Dumbass Records agreed, solely as an accommodation to Mr. Rapper, to make the payment to Gabey Baby on Mr. Rapper's behalf, an expense that Mr. Rapper ultimately bears. Number 5. Gabey Baby presented Dumbass Records with an invoice for the services, which noted that payment was due 90 days following the invoice date. Dumbass Records paid the invoice in full within that time period. The invoice included the following note: hired by Dumbass Manager. In conclusion, no employer-employee relationship ever existed between Dumbass Records and Gabey Baby, and therefore his case has no reasonable basis for consideration. Bum bum bum! I know at some level that letter was a bit of a scare tactic from the lawyers, but I didn't let that get to me. That night, I spent 2 hours writing a rebuttal letter responding to each one of the individual points that the lawyers for Dumbass Records listed in their letter. In my response, I made it very clear that I believed that my case had merit and should not be dismissed. The lawyers basically tried to say that Dumbass Records had no involvement with hiring me and didn't authorize Bum-Ass Manager to solicit my audio engineering services. They also attempted to pass financial responsibility onto Mr. Rapper, which I thought was just nuts. And while I can't agree that the best piece of evidence that the defense had was that I actually sent an invoice to Dumbass Records that had net 30 to 90 terms, I argued that that invoice was essentially void because the net 30 to 90 day terms were imposed on me, and I basically had no choice in the matter. So I wanted to argue that it was illegal for them to impose that, so that my invoice was essentially void. I argued that the work agreement between Dumbass Records and Bum-Ass Manager was irrelevant because Bum-Ass Manager acted as an agent for Dumbass Records by soliciting my services, which Dumbass Records eventually paid for, assuming financial responsibility. So I sent that letter back, and 1 week later, it was time for my phone conference. So 5 minutes before my conference, I dialed in, I typed in the access code, and I sat and waited for everything to start. The officer from the labor department who was mediating the whole call then started everything and went around asking who was present. I was there representing myself, and 2 lawyers were there representing Dumbass Records. The officer started out by asking me a few clarifying questions about my claim, sort of what happened, where it was, and what the full amount of my claim was. Then they asked the lawyers to briefly speak about their defense, and the lawyers then spent the next few minutes just like reading off that letter that they sent me the week before, which worked very well to my advantage because I was very prepared to respond to each of those points. After they spoke, the officer then asked me if I wanted to respond to any of the points from the defense, which I was very prepared to do because I had spent 2 hours writing that response letter just the week before. While I was speaking, I could hear the lawyers of the defense on the phone sighing and sounding very frustrated by what I was saying. At one point, one of them even interrupted me while I was talking. I told him, "Please, sir, if I could finish. I believe the question was asked of me. Thank you." And I think that really shut them up. Those lawyers were not ready for me to be as prepared as I was to rebuttal to their responses. After about 10-15 minutes of questions back and forth, the labor commissioner officer had all the information they needed about the case, and at that point, started the proceedings of settling the case by separating us into 2 separate conference rooms. The officer started speaking to the defense, so I was sitting waiting in a conference room all by myself. Then when the officer joined my conference room, they informed me what the defense's offer was. The first offer from the defense was insultingly low. It was less than 5% of the total amount that I believed I was owed with the waiting time penalty. I sent back a counteroffer. They didn't accept that offer and sent me a counteroffer. The counteroffers went back and forth until the defense said that that was their final offer and they were happy to argue a case in front of the judge. I told the officer that I would not be accepting their offer and that I was very vindicated in my claims that there was a working relationship established between Dumbass Records and Bum-Ass Manager, and that it was Dumbass Records' financial responsibility to pay me on time, which they did not, and that ultimately it was unlawful of Dumbass Records to impose the 30 to 90 day payment terms on me, and I would gladly argue that in front of the judge if the defense did not take my final offer. The defense accepted the final offer, which represented around 60% of my waiting time penalty, and both parties won. I got a nice fat settlement for my claim, and Dumbass Records did not incur more legal fees or have to pay me the full amount if we went to trial, and I won. So that's basically the full story of my claim against Dumbass Records and how we settled it. I want to just quickly add a few points as to why I made this video. It wasn't just to brag that I sued a record label and won, even though, yes, I did do that and it does feel really good. Part of what I wanted to do was to help dispel what I believe is a general misconception in the public, which I shared, which is that you need to hire a lawyer and go through a very expensive process if you want to sue someone or file a lawsuit. Believe it or not, that is just not true. The way I filed my claim was going onto the website of the California Labor Department, and in there, it gives you the instructions on how to file a claim. Like I said at the beginning of this video, if you're using this for research or some sort of assistance for a claim that you might be going through, I highly encourage you to go on your state or your local labor department's website and just look up the laws of your state and look into the process of filing a claim, because it's going to be different in every single state. There may be some cases or situations where you would need to hire a lawyer, but not specifically for my labor claim that I made here in California. So I just want to be very clear that if you're considering filing a claim in your own state, do very diligent research before you do so. I also want to encourage you to gather all of the documents and physical pieces of evidence that you might have to support your claim. This includes emails, text messages, contracts, basically any document or physical piece of communication that you can get your hands on. Gather all of that and have that prepared before you file a claim. Another reason why I made this video is because I'm just sick of corporate greed and sick of the little guy being taken advantage of. If you've been paid late, if you haven't been paid in full, or if you haven't been paid at all, you need to stand up for yourself and fight back against your employers. It is simply not okay, and wherever you live, there is a process for you to file a claim. The first 2 claims I actually filed like this were claims against casting companies that cast me to do work as a background actor and then didn't pay me in time. If you know anything about background acting, you know that there are days on film sets where there could be hundreds of background actors. And I've made a ton of close friends at these big background acting cattle calls, as they like to call it in the film industry. Background actors and ton of minimum wage workers get taken advantage of every single day in America. I know that I have friends that have been in a similar situation, and I want to be a voice for them. I'm hoping that the information that I share in this video can inspire a friend of mine or someone else in the creative industry who's been taken advantage of to stand up for themselves. So for all you freelance and creative workers out there, I encourage you to learn your local labor laws, to be very clear about the contracts that you sign, and to stand up to companies that don't pay you when and how much they need to. If you have any thoughts and questions about this, I would really love to hear them in the comments, and I will do the best I can to reply to as many as I can. And if you want to hear more stories like this, subscribe to my channel and let me know you liked it. Thanks so much for listening. Have a great rest of your day and take care of yourself. Bye-bye.